Okay, hello again. I am continuing my presentation on the legal context of sustainability, that is environmental law, and we have covered all of the major legislation and some of the political variations that have occurred since that legislation was passed, and now the next segment will cover the legal foundations and the administrative procedures surrounding the application of environmental law. So with that, let's get going. So the first thing that you need to know, and anyone needs to know about any kind of law, is that no act of Congress can be legitimate if it does not have a constitutional foundation. So the Constitution either has to specifically say, yes, Congress, you can make laws to create an army and a navy, which the Constitution does do. You can create post offices. Again, the Constitution says that. Something the Constitution does not say is you can make laws regulating the environment. So, as the slide indicates, rather than having an explicit, specific grant of power enabling Congress to pass laws concerning the environment, rather that power, the power to pass laws regarding the environment, has to be implied in the Constitution, or what we call implicitly found in the Constitution. Again, there's no explicit, specific statement in the Constitution that grants Congress the power to regulate the environment. But, as we'll see, there are implicit statements in the Constitution which Congress has used to justify environmental legislation. So those two justifications you can see at the bottom of this slide come from two separate parts of what's Article 1, Section 8, which is what lays the part of the Constitution that lays out the powers of the national government. The first thing that courts have accepted and the Congress has argued justify environmental legislation is something known as the Commerce Clause. It enables Congress to regulate trade, commerce, among the several states. So as long as something's happening between more than one state, some kind of commercial, business, economic activity, then that can be regulated by Congress. And most significant example of this is actually the Civil Rights Act, which bans discrimination in private businesses and whatnot. Any business that's engaged in interstate commerce, trade between the states, that business cannot discriminate on the basis of race or other categories like gender and ethnicity and religion. So anyway, the Commerce Clause covers any activity, business activity that takes place between the states. It is argued by Congress and has been accepted by the courts that environmental matters, whether they be the toxic wastes or the safe water, the air, the Superfund sites, the hazmats, marine animals, so on and so forth. Whatever argument, whatever area it is in environmental regulation, Congress has argued and the courts have accepted those areas are subject to congressional legislation if they choose to do that because they involve commercial activities between the states. Something as simple as, for instance, you saw a slide about acid rain, the amendments to the Clean Air Act prohibiting the kinds of airborne chemicals that contribute to acid rain, which, if you don't know, or not familiar with that, basically the factories, the soot-producing factories in the Midwest and the steel firms and whatnot, for example, in Pennsylvania, would emit these chemicals into the upper atmosphere, and they would be carried eastward by the jet stream, and then when it rained over places like Maine and New Hampshire, the rain would bring all those chemicals down and it started killing all the trees. Acid rain. It also gets into the water supply. It's not so healthy stuff either. So because of that externality, as Dr. LaCrone, I believe, discussed, because that externality, Congress can regulate that. So that's the Commerce Clause justification for environmental laws. And then the other thing in Article 1, Section 8 that it's important to note is something called the Necessary and Proper Clause. Necessary and Proper Clause says Congress can do whatever it thinks is necessary in order to do what the Constitution authorizes it to do. We already know the Constitution doesn't give Congress a specific power to regulate the environment. We do know that Congress has the power to regulate commerce when it takes place between businesses or whatever in two or more states. It is necessary and proper, according to the government and according to the courts that accept the argument, for Congress to regulate commerce between the states by, among other things, regulating environmental hazards. As I mentioned to you at the end of describing the legislative process when we got to sort of that stalemate on environmental legislation, I said that one of the things that has contributed to the lack of activity in Congress on legislating on the environment is the vast administrative process that has been put into place largely in the EPA in order to carry out all those laws that I showed to you earlier. So we need to understand then not just what those laws are and what they require and how they operate and what their justification is. We also need to know how they're carried out, how they are administered. And as I hope to demonstrate here, part of the legal context of environmental law and sustainability is the administrative process itself and a variety of very interesting and complex factors. Now, the EPA, interestingly enough, is not a cabinet-level agency. Boy, you sure would think it is, right? If Homeland Security is a cabinet-level agency, right, combining all these other agencies, why is EPA not a cabinet-level agency? EPA is not a cabinet-level agency because, frankly, EPA is controversial. There are people, lots of people, businesses, large organizations who oppose much of the work that the EPA does. And for that reason, Congress has never been, and presidents have never been, able to elevate the EPA to the level of the cabinet. Now, that doesn't mean it isn't an enormously powerful agency. It is enormously powerful, and the president has as much control over it as he does over any of the other agencies. When Congress passes a law that requires any kind of administrative agency action. I mean, sometimes Congress passes a law simply saying people can no longer do this or people can no longer do that. But if Congress passes a law requiring some administrative agency to take some action, that agency has to figure out what it is Congress wants it to do. And remember, of course, in this whole conversation, it's not just Congress, right? All those acts of Congress that I talked about, with the exception of the Clean Water Act under H.W. Bush, all of those actions were actually signed by the president, right? So the president's intentions, the president's purposes are also part of this. The process by which this takes place, by which agencies try to figure out what it is Congress wants them to do, is called rulemaking. There are three types of administrative or rulemaking rules. There are three types of rules that agencies administer in translating statutes, acts of Congress, into action. Interpretive rules, substantive rules, and procedural rules. Interpretive rules. Interpretive rules are very important because the agency is actually interpreting the language of the statute. And of course, this is not just some idle activity, right? You've got to get lawyers involved and scientists involved when it comes to environmental legislation, lawyers and scientists and policy analysts and all sorts of people reading this language. Most of these statutes are huge, thousands of pages with all sorts of sections and subsections, which I'm sparing you, of course. And the agency actually has to interpret all the meaningful passages that direct it to do something. What does Congress actually intend for us to do? And as we'll see in the last segment of this presentation, sometimes those interpretations can indeed be questioned in courts. However, for the most part, according to something called the Chevron rule, Don't worry about it. A court decision where the Supreme Court said interpretive rules cannot be challenged. An agency's interpretation of a statute and the intent of Congress is final as long as the agency does it in accordance with certain regulations and restrictions. So we'll see more about that in the final segment. Substantive rules. So now the agency knows what Congress wants it to do. Well, how are we going to do it? How are we going to carry out this requirement that Congress wants us to clean up the water? Congress wants us to identify hazardous waste sites. Congress wants to clean the air up. How are we supposed to carry this out? And that requires them to make rules, what we all know as regulations, right? I mean, people always talk about the regulatory burdens imposed by the Environmental Protection Agency on businesses and individuals and governments and so on and so forth. Of course, the same thing is true of, the Education Department has all sorts of regulations, the Transportation Department has all sorts of regulations, everybody has regulations. But again, those regulations are what we find in the substantive rules. And these are regulations saying, if you're in the business of using this particular chemical, you have to take these procedures in order to protect the public from any harm that that chemical might do. Procedural rules. Once the agency has figured out, well, what the regulations are, how are they going to enforce them? How are they going to be carried out? Recently, for instance, on the EPA website again, because of a court order, again, we'll come to that in the last segment, the role of courts, but according to a court order, farmers engaged in animal husbandry have to file paperwork, and a lot of it, identifying what the animals are, what they eat, and how their waste is disposed of, right? Those are procedural rules, right? We're all familiar with procedural rules because we all pay taxes. And those IRS forms, the 1040, that's a procedure. Okay, we're going to stop it there, and then we'll come back to see how you can object to rules.